Welcome back to our channel, Law Point. This is Shamal. Our previous sessions were on marriage and divorce laws among Hindus, Christians and Muslims. Today, we are dealing with frequently asked questions on this topic. We have our Supreme Court advocate on record, Ms. Praseena Elizabeth Joseph, to answer our queries. So let's move on to our first question. In case of interreligious marriage, which law governs the parties in terms of marriage, divorce and inheritance?
Interreligious marriages are governed by the Special Marriage Act. Indian Divorce Act governs the couples married under the Special Marriage Act, and Indian Succession Act governs the couples married under the Special Marriage Act. It is important to note herein that in case of registered marriage of a Hindu, Buddhist, Jain or Sikh with another Hindu, Buddhist, Jain or Sikh without following Hindu rituals as laid down under the Hindu Marriage Act are governed by the Special Marriage Act. However, with respect to succession of those Hindu couples, it is still governed by their personal law under Hindu Succession Act and not by Indian Succession Act.
Let's move on to a second question. If a woman happens to get married under force, fraud or misrepresentation, whether that marriage is valid in the eye of law?
If the consent of the complaining party has been obtained for the marriage by fraud or by force or by misrepresentation, then the complaining party can file a petition for annulment of the marriage. The petition for annulment of marriage need to be filed within a period of 1 year from the date the force or misrepresentation has been discovered. Most important of all, the complaining party should not have lived willingly with the other party after discovering the fraud or misrepresentation. Under the Indian Penal Code, whoever marries another person concealing his former marriage is considered as a punishable offence. Marriage can also be declared invalid if it can be proved that at the time of marriage the woman was pregnant because of another man.
Let's move on to our third question. If a husband files a divorce petition from his state of residence, can the wife who is staying in another state transfer the divorce petition to her state of residence?
Transfer petition is a petition filed before a superior court for transfer of a case pending before a particular court to another court. Transfer petition can be granted or allowed only by a superior court having supervisory jurisdiction over the court where the case is pending as well as over the court where the matter is to be transferred. Transfer petition can be filed either by husband or by wife on following grounds. If there is inconvenience on the part of husband or of wife, if there is reasonable apprehension in the mind of a particular party that he will not get justice from a particular court where the case is pending, or in case transfer is not made, there will be unnecessary expense and delay. In all these cases, transfer petition can be filed before a superior court. For example, if husband file a petition for custody of child before a family court in a particular district and wife file a petition for divorce before a family court of another district, but both these family courts are under the same high court. In this case, the husband or wife can file a transfer petition before the concerned high court for transfer of the case of child custody to the court where the petition for divorce is pending or vice versa. Now, in case the husband filed a petition for divorce before family court situated in a particular state and wife filed a custody of child petition before family court in another state, in that case, transfer petition can be filed by husband or by wife before the Honorable Supreme Court of India.
Let's move on to a final question. Family court can grant divorce by mutual consent to Hindus and Christians, but can it also grant the same to Muslims?
As we have already seen that divorce of Hindu couple are governed by the Hindu Marriage Act. Divorce of Christian couple are governed by the Indian Divorce Act. Muslim male divorces, that is talaq, are governed by Muslim personal laws. And Muslim women divorces are governed by the Dissolution of Muslim Marriage Act as well as by Muslim personal law. It is important to note herein that Hindu Marriage Act as well as Indian Divorce Act provides for special provisions for mutual consent divorce. However, the Dissolution of Muslim Marriage Act does not contain provision for mutual consent divorce. But under Muslim personal law, there are two ways in which Muslim man and woman can obtain divorce by mutual consent. That is by Mubarak or by Khula. If Muslim husband and wife feel that they are not compatible with each other, then they can get divorced by mutual consent through Mubarak. Second form of obtaining mutual consent divorce under the Muslim personal law is by Khula. Here, offer of divorce is initiated by the Muslim wife to the husband by paying him X amount of money, or she give up her meher which is due from her husband. And if the husband accept this offer, then after a reconciliation mediation between the parties, both the parties can obtain divorce by mutual consent.
Thank you for watching. See you next week with another legal topic. Till then, bye.